Okay, I am calling to order this NCTD Executive Committee meeting for October 1st, 2020. Anthony, please call roll.
Yes, sir. Tony Krantz,
Here.
Jack Feller,
Here.
Sharon Jenkins, Jewel Edson.
Here.
Anthony, are there any changes to the agenda?
No, sir.
And do we have any public comments today?
No, sir.
All right, agenda item number 1. There's one item on the agenda today, and Jacob Gould, the senior legal counsel, will review it, which includes proposed modifications to NCTD board policies.
All right. Good afternoon. This is our annual update to the board policies. We have a few that we've made substantive revisions to, which we'll go over. The remaining are really just minor modifications, either to update staffing, positions, or to correct some internal inconsistencies or things like that. So board policy number 1 establishes the process for adopting these rules and the annual review. And we are recommending substantive revisions to board policy number 2, which is appointment of the board members. Number 3, committee external appointments. Policy 19, which is delegation of authority of the executive director. Board policy number 26, which is the discrimination complaint procedures. And tied to that is board policy 27, which is the EEO or equal employment opportunity policy. Like I said, most of these are not substantive in nature, are really just annual updates that we do, are good, better, best, right? We keep moving forward. And we will focus in on the substantive changes. So in the first one, board policy 2, appointment of the board of directors, we have updated this basically to formally implement what we have done historically in the past. So all new board members will now attend an onboard training where we go over all of the board policies and the government's issues specific to NCTD. We've historically done this in workshops. The last round, we actually did this sort of one-on-one with each new board member at their schedule. So this just codifies what we've done in the past. We believe these are important things for all board members to know and just puts that down in writing. Committee and external appointments. This is modified, so basically to comply with California law in terms of the executive director and general counsel's employment agreement. Any revisions of those will go to the full board. And then the second one is if a committee member cannot attend one of the committee meetings, we're making it explicit that the alternate may attend that committee meeting. There was some misunderstandings with how the policy was written, so we've made that clear to correct that. So those are the two things. First one we've done in the past as well. So this is just codifying those. Board policy 19, we are increasing the authority of the executive director to award a revenue generating contract. So this is bringing money in from $100,000 to $200,000. And this is also in line with the modification that was done to board policy 19 when we upped the limits across the board when we joined that alphabet soup of the Cost Construction Accounting Act. So now it's $200,000 across the board for approval of an initial contract. Discrimination and complaint procedures. This one, as well as 27, are really implementing updates from the employee handbook. So these are a lot of things that have been in the employee handbook that we're moving into the policy so that they're all consistent. Clarifying the applicability of these procedures to members of the public. So we're making clear what avenues the public has to make claims or clarifications. The complaint filing options. Before we had some time limits in there. Those vary based on the facts of the underlying complaint. So we didn't want to give somebody an inaccurate time. So we've modified that. And then additional filing options. These are for non-NCD employees. So basically members of the public or third parties to make that clear as to what options are available to the public. And then the last one, board policy number 27, is the equal employment opportunity policy. This is sort of the flip side to the discrimination complaint procedures. Again, this is implementing updates from the employee handbook, clarifying our investigatory procedures, who applicants and employees may file a complaint with. So we're explicitly listing those out. and then also explicitly saying that third-party investigators may be used in cases where there may be an internal conflict. So if there's an allegation against somebody who may be actually investigating that claim, we can bring in a third party, so we maintain that impartiality. Non-substantive changes is this list here. I won't read through this, but the vast majority of these, like I said, are just sort of minor updates. We've updated titles for various positions that have been modified or replaced. Retention schedule, the annual update, that includes all of the legal requirements for making sure that we're in compliance with California law and any federal regulations for maintenance of records. Those types of things. The joint use and development, we rearranged that so that our CEQA analysis was all in one place instead of a couple places, because we did receive some questions through this last RFP. So those are really just cleanup items. So assuming the executive committee does approve these modifications, they'll be advanced to the October board meeting for the full board. We'll be requesting adoption of a resolution for approval of these changes on the consent agenda. So any questions on any of the modifications to the policies? You all should have a black line of them as well if there's any specific questions. But,
Jewel, you have any questions?
No, I have no questions so far. Thank you.
I didn't see the black line version. The question I have relates to board policy number 27, the equal employment opportunity. Does the policy spell out when the third-party investigators will be used?
no, it just gives us the opportunity to use them. Typically, they're only used where there's a potential conflict within the agency.
And that's at the discretion of the legal chief legal counsel?
Typically, the CRO would consult with general counsel, sometimes the chief admin and the executive director. It's going to depend on what the conflict is and where that occurs.
Okay, and that wouldn't be something that the board would have any business involving themselves with. It's just in adding the language that says it may happen.
Yes, because, and just to provide clarity about it, because the chief, the civil rights officer reports to the general counsel's office. So play out different scenarios. If it involved me, obviously they wouldn't be communicating with me. And if it involved me in a substantive, significant way, general counsel would obviously reach out to the board chair and have communications around these types of issues. So,
all right, and I just in this business, the may versus the shalls are sometimes they leave some room for interpretation, and so I think it would be not that I want to spell out every time and try and put some shalls to it, but it would be useful for potential complaint makers if they had a clear understanding of when those circumstances would dictate that it would be used, it shall be used.
are you referring to outside?
Yes.
Well, I think that's why you have the may, because it will all get down to the facts and circumstances of the issue.
And I'm okay with that. It's just that I guess the question then becomes, what recourse does someone have if they think that there should be? And who's the ultimate arbiter of that?
Well, so what we're talking about here is the internal investigation. If there is a complaint that alleges that there was some sort of misconduct or something in terms of the investigation, there's always the appeal process. And it depends on what the complaint is based on, where that appeal goes.
Yes, and in board policy 19, the additional authority of the executive director, as with all the other items, this contract that you might sign would come to the board on consent generally as part of the next.
Well, you get a quarterly report for actions taken under the authority of the executive director. So right now, this really just aligns with the $200,000 authority that the board already granted to me. But you do get all actions done under my authority in a quarterly report from the procurement department.
Okay. Any questions, Jeff?
I'm curious, we don't at the city of Oceanside do drug testing on council members. Do they do that on board members for an agency like this?
No, so the policy right now for the drug and alcohol is we have classifications both as required under state and federal law. Typically our operators, safety folks, we have positions that we've designated as safety sensitive positions that get regular testing. Anybody is subject to, suspicion testing. So, if you have somebody who tumbles down the stairs and the first person there smells alcohol in their breath, they may get tested. But no, not under the base sensitive position or designated position.
So if there's an accident, it's certainly possible at that point. Don't test me for chocolate, that's all I have.
Yes, I was wondering if there was a particular board member you had in mind for testing. Chocolate, yes. No questions. We're sorry we got started, Sharon. All right. And so if there are no questions, I would entertain a motion. Is that what we need to vote on this?
So Tony, this is Jewel. I actually have a question before we move there.
Okay.
Under Board Policy 13, the word might was redlined to reasonably, but it says no, for example, no advertisement will be permitted that reasonably be interpreted. So there's a lot of reasonably be, which doesn't necessarily make for good sentence reading. Was that corrected in a later version? Because these were the late revisions from yesterday, the red line.
Find where you're at.
So Board Policy 13, page 2.
I see. So we're on 2 and 3. Yeah, so no advertisement will be permitted that reasonably be interpreted to offensive or any religious, ethnic, racial, or political group. We included the reasonable standard versus the might because there was some potential confusion as to what is might. Typically, the word reasonable does have a legal connotation. It's the infamous reasonable person that I've never been able to find, but the court has a standard for. And it does read a little bit funny, but that's sort of the standard that is used in several other jurisdictions.
Okay, thank you.
So we need a motion?
There's no formal votes or just a consensus to move it forward.
Consensus has been obtained. Okay. The next item is a closed session item, and Jacob will now take us into closed session.
All right, so we are now entering into closed session pursuant to Government Code 54957.6, Public Employee Performance Evaluation for Matthew Tucker, Executive Director. This will be led by Karen Tucholsky, Chief Administrative Officer. We're actually going to move into that room.
Somebody could walk by reading lips. Broadcast it on TV.
Exactly.
YouTube.
This is more so you can kick Matt out.
Ms. Essen, can you hear me?
Yes, I can.
Just as a reminder, you'll have to disconnect from this meeting and connect to the closed session link I sent you.
Okay. I have a lot here, so let me try to find the correct one. I thought this was the closed session link, sorry. Special special meeting, special meeting, special meeting. Updated board, updated revision, special meeting. Touch PowerPoint, Zoom webinar for those participating remotely in a special meeting. To the Zoom information of Tuesday's executive committee. That was what I signed into, I thought. Let me turn off and try to find it again, okay?
Right there in that same email, ma'am, there's a second link below for closed session.
Okay. Oh, that would be my bad. Okay, I'll be
All
right
right.
with you. Thanks.
Okay, the executive committee is returning from closed session. There's no action to report at this time.
Okay, thank you, Jacob. And Mr. Tucker, do you have anything to report in the executive director's report?
No, sir. No, sir.
Do any committee members have anything they would like to report? Anthony, do we have any remaining public comments?
Oh, sir.
The next scheduled meeting is at 2 o'clock. Was supposed to start 4 minutes ago. So here we go. This meeting is adjourned. Okay, give us a couple minutes just to get all geared up here.